Hi everyone. So, in my previous lectures, I have dealt with the functional and the modular conceptions of law, and I explained from the perspectives of Hart, of Dworkin, Phyllis, Simmons. I will explain the details of the debates much more in the near future. However, in this video or in this lecture, I would like to talk about a basic fundamental problem in general jurisprudence that I have analyzed in recent years while reading about it. And that is the metaphysical grounding problem, which is a very positivist misnomer. I would say that it is a shame that people who do PhDs and JDs of metaphysics actually hijack this field in terms of law and take their degrees out of it. Whereas the whole point of general jurisprudence was not regarding the grounding problem at all. And I have even told in my previous videos that it is a misnomer completely. So in this video, I would like to talk about the grounding problems which has been put forward by I would say misnomer in terms of a positivist, who I would say so, because he is much more of a clueless fellow than a positivist, I would say, or rather, I would say a disgrace to the word of positivism, and yet has time to post on Blue Sky or X or whatever he goes on and banters about positivist ideals or knowledge that he shows off. But to me, he's not. He is simply a fool, or he makes a fool out of himself. So that's Scott Shapiro, by the way. And I will talk about his point of view. I have read his book Legalities. I was feeling so pathetic with myself that to read that book further, but I have still highlighted some of his views rather than going to his main theory of law, which is completely fallacious in my first viewpoint. So I will put him against, I would say, a very knowledgeable and an erudite fellow or a professor in jurisprudence, a legal realist, philosophical naturalist, Professor Brian Leiter. He has written a very explosive article, and his book is also coming out. So, from I'll share about that later. But he has given his views in one of his chapters, which he has recently released on SSRN, and that's basically completely laying to rest the claims of Shapiro, the likes of Shapiro, as well as Mark Greenberg, another person who Shapiro follows to make his own positivist camp and say that it's a positivist position that he's defending, and he has the tenacity to go against HLA Hart as well. So I will reveal everything. So let's start with what Shapiro's point of view is. So Shapiro basically says the legal facts are not metaphysically basic. They depend on a further social facts, or which can be more metaphysically basic facts like social facts, or it can be from a naturalist law position that it can be of social facts plus moral facts. Now he uses paradoxes or puzzles to solve it, because for him that's the most intriguing work that he has done in it, that he has introduced us to this paradox, which is called the chicken egg puzzle. Now he frames this chicken egg puzzle in terms of the possibility puzzle. He doesn't frame it in terms of whether the chicken came first or the egg came first. It is not a perspective of priority, rather it is a perspective of possibility. How a chicken or an egg is possible. Now we understand the fact that chickens hatch from eggs and lay eggs. So when it comes to law, in some place we say that an entity is supposed to have a legal authority, but in order for that entity to have a legal authority, there must be some rule behind it that gives it the power to have legal authority in the first place, to enforce it. So I'll give an example. Let's say in terms of US Constitution, consider there is a recession that is taking place, and we are looking for Congress to adopt a stimulus plan. So we look into Article 1. So when we look at Article 1 of the US Constitution, during a recession, there is the Congress, when considering a stimulus plan, the most relevant provision is the spending clause, which is in Article 1, Section 8, Clause 1, which says that the Congress shall have the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. So Congress can justify this stimulus plan on the basis of general welfare of the people, and they can spend it, the federal money, in terms of the nation's overall health. However, the constitutional question, which I mean the constitutional lawyers can say it better than me, is that the issue is not whether Congress can pass a stimulus plan, but the issue is rather the specific mechanisms and scope of the spending program, which is by virtue, if you look at the necessary proper clause under Section 8, Clause 18, which gives Congress flexibility to implement spending programs effectively, or the Commerce Clause, which is Section 8, Clause 3, which regulates interstate commerce and justifies aid to business and infrastructure. But then we ask why Article 1 is valid. We look at Article 7, which says that the Constitution has a thing called Article 7, which states that 3/4 of the original state has ratified the Constitution and the Constitution is valid. So something which gives authority to the Constitution is itself a part of the Constitution, makes it an infinite regress argument. So from where did Article 7 get its validity or its authority? So it's a viciously circular argument, I agree. And part of it, how Shapiro says from his book that we can get out of it through this chicken egg paradox, is either negating any one of the principles, which is either the egg principle, which is the rules, or the chicken principle, which is the legal authority. So by denying egg principle, he was to go back to Austinian camp of saying that law comes from an ultimate sovereign, which is a brute political power, which has the ultimate authority to create rules. But going by this logic, he is grounding legal facts on social facts of brute political power. This is what Shapiro claims, by the way. So according to him, if Austinian camp bases the argument of an ultimate authority of sovereign on a social fact, which is a misnomer in the first place, because you can't consider it a social fact alone, because there can be mental facts, there can be other facts, geographical facts as well, which I will argue further from Leiter's position, from Professor Brian Leiter's position. So he comes to a fancy conclusion that you have to, it falls into a Hume's problem or a Hume's law, that you cannot derive an ought from an is. That is a normative conclusion as to derive from a normative premise. So he gives an example. Let's say you ought to take your jacket because it's cold outside. Now this is not a complete argument, because there is a suppressed descriptive premise that you will catch cold. Therefore, you have a suppressed normative premise that you ought to catch cold, so you ought to take your jacket because you ought not to catch cold. This is the complete argument, according to Shapiro. And I also claim that this is valid. So if legal facts that depends on social facts alone and not on moral facts, any kind of argument that a legal fact runs into a descriptive premise will miss a normative premise. But this is a false claim in the first place, because positivists never really say that legal facts depend or ground on social facts alone. Because for positivists, let's say there is a law that prohibits you to do jaywalking, which I will come to later. Professor Brian has given this example in a particular jurisdiction. Now that jurisdiction itself can have a distinguished rule. That doesn't mean that it is grounded on a social fact. And the whole point of Shapiro's claim, from his viewpoint that he brings into his planning theory of rule of law, is to reject Hart's viewpoint as a categorical mistake, to say that rule of recognition doesn't derive itself from a social, like it derives itself from a social fact alone. So how is it possible? So how is this metaphysically possible for us to accept that the rule of recognition is derived from a social fact alone. Now, the argument can be said from a various standpoint, but I will come to it later. But the point which I am trying to make is that from Shapiro, law seems to have normative claims. However, the basic premise is that if you are vindicating yourself in this position, sometimes you have to look into what Ras says. Ras says the law lacks legitimate authority. It claims legitimate authority, so it lacks it in the first instance, so it claims for it. So when it claims for it, the argument is that sometimes you have to detach yourself from the normative positions that you take. Let's say you are arguing for a position that this is a particular valid law which says that you have to plan your estate in a particular manner. I wouldn't look at the moralistic conceptions of whether or not this makes my case morally stronger, because if it doesn't, then why did I hire that lawyer? If I have a client, I would fire him and I will hire somebody else, because I have to plan my estate. So I have to look at the legal norms, I have to look at the legal rules, I have to make it in such a way that even if I don't support the particular position of how the estate is to be planned morally or by own personal preferences, I have to give my preferences from the viewpoint of my client to save him, to benefit him. So Shapiro says that law seems to have normative claims. What you're legally required to do, legally permitted to do, and legally allowed to do, it becomes an odd case. So he says that positivists have no access to normative principles which allow somebody to derive a normative claim about what a law requires. That is why when he says that this problem is simply from the perspective, if you say that what a law requires, you don't have a normative claim to back it up, so how can law be grounded on social facts? That's his argument. Because for him, natural laws necessarily don't have this argument, which is a very falsifiable viewpoint for me in the first place, because if you look at what the positivist actual position is, positivists say that the validity of rules being a rule is not simply talking about the constitutive premise of a rule. It's not simply talking about whether or not the rules are constituted by the basic necessities of the universe. That's simply not our task. That's simply not the general jurisprudence task. Before 2004, after 2004, this shouldn't be the case. But these guys have just used it for their own purpose and made the literature much more divergent, and then it brought out anti-positivist claims about eliminativism and all those freakish theories that I don't know what's the point of when the positivists haven't talked about it. They've talked about validity and not the content. So when they say that law is not talked about from the ground of whether or not it is ultimately constituted by something or how something makes up a law, they are simply claiming that how a rule of recognition, which itself is a rule that can talk about the validity of a primary rule as well as a secondary rule, it gives primacy to it. That is the main crux of it. That is the main crux of positivism, which I have been highlighting in my previous videos. Because if you look at it from a very basic standpoint, the jurisdiction wise, there will be no demarcation. Because if you consider a particular legal system having a rule of recognition which allows you to stone someone to death because he is cheating, and there is another legal system which basically fines you, so if you don't allow this, or if you ground it on social fact alone and you want to find out the basic distinction or the ultimate constituents of the fundamental position, then you are looking at it from the viewpoint of how jurisdictions differ from this. Then you are simply wanting to eliminate jurisdictions and not respect legal systems. So I'll come to the two papers I have read in my recent past about legal systems by Professor Rabanos and Professor Raz. I'll talk about that later, but the point I have tried to make, I hope you guys understand. Now, besides for him, so basically we don't do legal theory to worry about methodological issues. We don't do constitution of morality, that is a subject of meta ethics, which I agree, and we don't look at constitution of social facts, which is a subject of philosophy of social ontology. We are not, so the argument is we are not getting to the rock bottom of metaphysics of the world. We have to bracket certain things out to make it metaphysically, and you know, and if you're bracketing some things out to make it metaphysically basic of social facts and moral facts, why talk about metaphysical grounding? You're getting me? So we need to say somewhere that the social facts or the moral facts on which legal facts are dependent upon is itself not metaphysically basic. So why are we talking about metaphysics? Why are we wanting to ground social facts, or why are we wanting to ground moral facts and look at some definitive answer when legal facts itself is not grounded by both of these things, which are not metaphysically basic? So you're getting me? So now I'll come to Professor Brian Leiter's paper, which I got to know from Lawrence Solom's, Professor Solom's X handle. He posts papers every day frequently. He's also a very avid, I would say, constitutional interpretivist. Like, he talks about originalist and living constitution. He talks about statutory interpretation and all, and ethics. So he posted that Brian Leiter posted a book from his book. So basically, Brian Leiter's book is about to come out. So that's the book's name is From Realist Point of View, where he discusses the chapter The Metaphysical Turn in Recent American Jurisprudence. Now he basically goes against two individuals. One is that he goes against Mark Greenberg, and second is that he goes against Scott Shapiro. Now we have seen an influx in the academy of very smart PhD lawyers with some law degrees, some with not, attuned to the latest fads in analytical philosophy, but with an interest in law founded by Greenberg's formulations, which are seductive without realizing how little they have to do with the traditional problems of legal general jurisprudence. Nearly all philosophers of law agree that non-normative, non-evaluative, contingent facts, which are descriptive facts for short, are among the determinants of the content of law. Hart says that his viewpoint is necessarily a contingent viewpoint, not a necessary viewpoint. That's why a game of rules of chess or a rule of football distinguishes from each other, because it is talking about the system from the basis of which it is being played about. It is talking about from the system in which the officials converge and practice that rule, practice that system. Otherwise, like if the rules of chess were applied to rule of football, you can imagine what's the idiosyncrasies that can lie there. I don't want to get into that point. So for Greenberg, he says that the central debate in philosophy of law is a debate over whether value facts are among the determinants contents of law, though the debate is not usually characterized in that way. He has parenthesized this point, though the debate is not usually characterized in that way. In his book, in his article How Facts Made Law, in page 157, if you look at it. So the debate was never about determinants of content. Kelsen too argued from his pure theory of law. I'll quote Kelsen. So Kelsen says that pure theory of law is a theory of positive law, a general theory of law, not a presentation or interpretation of a special legal order. From a comparison of all the phenomena which go under the name of law, it seeks to discover the nature of law itself, to determine its structure and its typical forms, independent of the changing content which it exhibits at different times and among different peoples. In this manner, it derives the fundamental principles by means of which a legal order can be comprehended. As a theory, its sole purpose is to know its subject. It answers the question of what the law is and not what the law ought to be. The latter is question one of politics, while pure theory is the law of science. This is Hans Kelsen, by the way, from his article The Pure Theory of Law and Analytical Jurisprudence in Harvard Law Review. So Greenberg is interestingly calls that this is something which he calls a rational determination, which he accounts and explains why legal facts should depend on the legal practices in some specific way rather than another one. Because what he says, and I quote in How Facts Made Law from page 158 to 159, the basic gist of it, what he has written. Whether law practices are the sole determinants of legal content, the determination relation with which we are concerned is primarily a metaphysical or constitutive one. No legal content facts are plausibly metaphysically basic or ultimate facts about the universe. Facts for which there is nothing to say about what makes them the case. Legal content facts, like facts about the meanings of the words, which is semantic content, or facts about international exchange rates, hold in virtue of more basic facts. The important implication for present purposes is that the full story of how the determinants of legal content make the law what it is cannot take any legal content as given. The basic historical premise is that the point of legal jurisprudence was not about content, it was about validity. The central question was about legal validity of sources. There were certainly questions about how valid norms were applied in particular cases, but even then they were not questions of determinants of contents, because that was not the topic of general jurisprudence. Raz in his sources thesis has also pointed out that it was not basically a purpose of testing the efficacy, it was a purpose of testing the efficacy and validity of a norm rather than testing the validity of content. However, he points out certain vague, ambiguous terms like interpretative sources from where we have to identify particular sources to it. I'll highlight that point later. But even if you come closer to Dworkin, in his book The Law's Empire, about grounds of law, he also did not mean about metaphysical grounds, just the considerations of propositions that would justify identifying some norms as legally valid or true. So you can see that Dworkin is a person who likes to invent new words. He eschews the Kelserian talk of validity and heart which he uses, and considering this, he frames it in a way that we are not talking about grounding of law, we are talking about identifying some norms as legally valid. That doesn't make it metaphysically basic. So, are you realizing where? So basically, the point is that how valid laws are to be applied, even then, determinants of content was never the topic of general jurisprudence. We don't talk about the constitutive facts about what makes social facts, what makes moral facts, what makes legal facts, whether it's social facts or whether it's social facts plus moral facts. We don't talk about that, because one can think of actual topic of general jurisprudence. One can think about, everyone knows that there are many norms governing human conduct in a society. Do not talk with your mouth full at the table. Do not drive faster than a certain speed limit on the highway. Do consider how your actions affect the interest of others. Do say please and thank you. Do not cheat on exams. Do not assault other people. Some of these norms are legal norms which are legally valid. That is, they exist as norms of the legal system, and some are not. They are etiquettes, social etiquettes. So what is for the norms to exist as norms of a legal system to be valid? In this much more conventional formulation of the topic, there is no question about metaphysical determinants of the content of legal norms. The content of the norms is taken for granted. That is my point. So in support of this different formulation, Greenberg only cites Ras to make his case, who indeed says stuff like the existential content of every law is fully determined by social sources. So in his book The Authority of Law, at page 46, he has written this. So he calls it basically a crude formulation. One occasion where Raz does explicitly address the question of content is this curious passage that he has said, that the sources of law are those facts by virtue of which it is valid and which identify its content. This says the source is wider than that of formal sources, which are those establishing the validity of a law. Source, as used here, includes also interpretative sources, namely all the relevant interpretative materials. This is an odd formulation for me. What are interpretative materials? In what sense are they social sources? A way of interpreting sources is not obviously itself a source as opposed to way of reading a source. It is basically a hermeneutic technique or a method. Assume what Raz has in mind like a source-based hermeneutic principle in the system of a law. The original intent of the framers of the constitution, he wants to frame it that way. Surely, however, it would be clearly able to distinguish between sources of law and way of interpreting those sources. So, interpretative sources are not itself determinant of the content of law, as what Raz is trying to implicate. Because an established legal practice cannot explicitly have a source-based content. Some may differ from the framer's original content, some may look at the constitutive materials, so the source is itself different. So his law, so it opens the door for Greenberg's idea, because there he says that explaining content is one of the questions that positivist theories try to answer, which is not. Positivists are not trying to answer the content, the determinants of contents on the basis of the validity of sources or rules. Those are separate questions. They are taken for granted. The determinants of contents are taken for granted. Positivists are talking about the validity of sources or rules that justify the governance of human conduct in the society. That is what primary rules and secondary rules talks about. That is what primary rules are, which governs whether or not people should do, whether they ought to do, or whether they ought not to do, or what is the case or what is not the case. And secondary rules is about the primary rules from a neutral perspective to adjudicate whether those primary rules are able to be established in a particular rule or not. And both these rules are given primacy or efficacy through a rule of recognition, which gives validity to such rules. This is the basic point. Now, I will talk about an interesting thing what Greenberg dubs the standard picture. In a simple thought, he says that meaning of legal text in a public language of the community is central to law. Yet everyone acknowledges that law can use public meaning of words to radically alter the meaning of legal text through statutory definition of terms, through judicial holdings about the interpretation of legal text, through administrative agencies' interpretation of text. This shows that his standard picture that legal text in the public language of the community is a central thesis of the standard picture of law is itself not standard and itself not central. This shows the hypocrisy. So it is right that the natural language in a community is a starting point for law, since law can only fulfill guidance function if in fact it can rely on that shared language as a benchmark for guidance. Now law simply cannot do without the meaning of legal text, as Greenberg puts it, even if that meaning can vary quite dramatically from the meaning of the same words in the natural language. Let us call the following the real standard picture to distinguish from Greenberg's invention, which is what Professor Leiter talks about. The meaning of the word, and I quote, the meaning of the words in the public language of the community is a starting point for the content of the law, with all kinds of modifications of those meanings possible in accordance with the rule of recognition of that legal system, which itself often utilizes the public language. Since the content of rule of recognition is equivalent to the content of the criteria of legal validity, officials actually converge or accept from an internal point of view. It is generally available to lawyers advising citizens about what the content of the law is. Part of learning the law is learning the rule of recognition in a particular legal system. Are you getting me? So, a content, what we are talking about is a criteria of legal validity that itself is given primacy through the content of rule of recognition, through which the practitioners or the officials converge and accept it from an internal point of view, being in that system. Thereby, a lawyer advises citizens what the content of the law is. Part of which is to say that the rule of recognition gives the efficacy or the validity to these laws in the legal system. So you have to recognize the rule of recognition first. Give you a simple example of the rule of football that I have talked about in the previous video. So a rule of recognition, which is, let's say, an FA rule, which grants you to play football with your feet and not with your hands, is a rule which the officials converge upon and accept from an internal point of view, that is the footballers which are playing that game, with the rules in which they are playing, with the rules in which the FA has laid out. This is to test the criteria of the legal validity of the content. The basic fact that the FA is being governed by a rule of recognition to be given this privacy to play football in such a manner and for officials to accept it from the internal point of view is the basic source. We are not concerned about how FA was grounded upon by such rules to make such a rule in the first place. We are not concerned about the constitutional basic facts of the universe that makes up FAs to make such a rule up. We are simply concerned about the internal point of view from the basis of which rule of recognition guides us to how people should conduct their ways in a given society, because the determinants of the social constituents of the universe or the metaphysical facts are taken for granted. This is what the positivist claims and its stance is. Before 2004 and after Greenberg or Scott Shapiro, whatever they came up with, this was the position which I have been consistently advocating about. Now I'll talk about something which basically I'll so in short what I'm trying to say, I'll talk about that. So in short what I'm trying to say is, if legal content is in the same metaphysical determination mode as semantic content and the content of projectable predicates in scientific theories, then why expect legal philosophers to solve the problem? Let's say in philosophy of science, in the mid 20th century, philosophers considered the question what distinguishes science from pseudoscience. Karl Popper proposed the answer that scientific hypotheses are falsifiable. That is, they can be negated. In neither case did anyone talk about the metaphysical determinants of a science fact. One can imagine how the answers actually given might be translated into Greenberg's metaphysical determinant question, but the question is why one should want to do that. It might create publication opportunities for recent PhD trained in metaphysics about what would we learn about what we have not learned from the existing debates. What were the existing debates? Think of it in this way. Not every act people think is morally required is legally required. Not everything that people think is morally prohibited is legally prohibited. Not everything legally required coincides with what people think is morally required. And so too with legal prohibitions. Law and morality both address human behaviors in multivarious ways, which is why the standing question of their relation has been so important. What we want to know as a theoretical matter is not how facts determine legal content. I repeat, we as a theoretical matter are not concerned about how facts determine legal content. What we want to know is whether the moral value of a norm does or should make it legally valid, and whether the immorality of a norm does or should make it legally invalid. This is what the general jurisprudence has been for a quarter of a century prior to what this fellow Greenberg and Scott Shapiro came up with, because the morality is linked to legal validity. The content of a legal norm or moral value of a legal norm is to justify whether or not it is legally valid in a particular instance or not. Because a legal norm, if it is morally prohibited, cannot in the same manner be also legally prohibited, because moral obligations are not transcribed to legal obligations, is my point. This question is also closely tied, at least for Dawkins, with the question of how judges should decide the case. Actually, positivists have generally thought the question about which norms are legally valid and how judges should decide the cases are separate questions. I'm repeating once again, the whole quest of general jurisprudence has not been about how facts make the case that a rule has a particular meaning. Why would anyone think how facts make law? Why would anyone go into how facts make law through its semantic basis and metaphysical basis to justify whether or not how facts make law? Because if that were so, then philosophical sciences, philosophical ontology, philosophical theories would haven't have distinctions in branches. We wouldn't have ontology as a separate branch. We wouldn't have philosophy of law as a separate branch. We wouldn't have philosophy of science as separate branches, or metaphysics or metaethics as separate branches. Simply presuming a very, a very anti-realist point of view, or presuming a sort of a point of view where you reject a moral expressivist claim and then you look at it from an intuitionist claim is very problematic. So what I want to talk about is that anyone interested in a theory of legal content already has the resources for answering the question, and more importantly, the answer will vary by legal jurisdiction. Because if that were not so in the case of what I was arguing about, the distinction between a jurisdiction would itself extinguish. The content of law is determined by a mix of authoritative and hierarchically organized sources, their meanings based on the meanings of the words in the public language of the community, but with substantial modifications to those meanings involving authoritative stipulation, precedent, customs, rules of interpretation specified by the rule of recognition in a particular legal system. Now I'll stop here and I will go to the second part of this video where I'll talk about how Professor Brian Leiter responds to Professor Scott Shapiro's hysterical claims about positivist claims. So this was about how Professor Greenberg has taken his stance. So the idea I have told you is very basically clear, that what we are talking about is that what gives primacy is a rule of recognition that gives itself validity to these rules, whether or not the rules needs to be morally binding or not. That needs to be decided on the touchstone of a rule of recognition which gives validity to such norms. That said, a moral norm being a legal norm is something which is completely misnomer, because not every moral norm which are legally prohibited can be a legal norm. They are separate. So I'll stop here and I will go to the second part of the video where I'll talk about Shapiro's claims and I will talk about Professor Brian's response to it, and stay tuned.